2018, the entire exercise had come to an end.
Lordship.
Yes, what do you say, Mr. Counsel?
I'm not the leading counsel, my lord.
So you are also consenting to an adjournment. Why should I come in between? When is that case is fixed?
Lordship, I'm not exactly
Okay,
aware of the date.
we'll adjourn it for 4 weeks and then we'll see what happens.
No, my lord.
As-
It will be better to come up after 2 weeks because my senior is indisposed.
Lordship, before the disposal of the
As prayed for by the learned counsel for the parties, registry to list this matter again on
19, my lord.
25 to 2026. You get that thing disposed of. Because there was an order saying that by division bench, single bench, coordinate bench order that 2000 calculation should be on the basis of 2013 Act. You have gone up against that.
No, Lordship, in fact, there was a conflicting views.
One earlier judgment
Yes.
was that this is not applicable.
Yes, and in another writ petition, this court says this is applicable. So there's a conflict in
But there is already a decision. I'm also an part of that bench pertaining to Mizoram, wherein the Mizoram thing was set aside and the 2013 Act was held to be holding the field. They have gone up on appeal before the Supreme Court. I don't know what has happened.
Lordship,
Give you a advice, my lord.
if it will be Wednesday, Lordship, it can be listed on 26.
26. Sorry. 26.
I'm deeply obliged.
Yes.
May I please, Your Lordship?
Hmm.
Your Lordship, I beg to mention item number 2 on behalf of my colleague Mosam, Your Lordship. He's indisposed, so kindly let the letter come up after 3 weeks. Your state is yet to file
He
application.
is so serious that he'll not be coming to court for 3 weeks.
Your Lordship, he has asked to, he's in bereavement, Your Lordship.
He is in bereavement. Yes, madam. No objection. Anybody appearing for the respond number 7 here? Nobody has entered appearance. Just give me that. Just wait for 2 minutes. We'll just come. Second item only will come. Yes, item number 1.
Please, Your Lordship, I beg to mention item number 6. Your Lordship, just last Friday, we have received a counter affidavit filed by the respondents. Therefore, kindly grant us 3 weeks' time to file a reply.
I'll give it. Let it reach. I'll give it. Let me also do some work. I mean, yeah. Yes.
For admission, item number 1.
Yes, Your Lordship.
Hmm.
Lordship, we're here to file additional affidavit.
Go.
So if short date maybe.
Why additional affidavit? What for? What are you bringing on record?
Some series of communication between the department as well as the petitioner.
For what? You're still behind the bars or you're out now? Out now. What is the error here?
Lordship,
What is the error in the conduct of the proceedings?
petitioner was not given the opportunity to be heard.
Heard. I deem that he was heard. Okay? You say that he was not given an opportunity to cross-examine.
Yes.
That's the,
Proceed.
mind you, be very careful what you're saying. Your ground is that no cross-examination accepted. Second ground is the ER has not been given. Inquiry report has not been given. But you come to your statement. You have admitted to everything. Once you have admitted to everything, where is the requirement of going through the whole formality again? And counsel, you have not raised any plea that you were in any manner prejudiced because the proceedings was held inside the jail premises. You have not even said anything about it.
The trial is still going on, Lordship.
Trial will go on. And the boy may have now been, because being inside jail, he is not getting supplies. So he may also have become good. He is also de-addicted now, forcefully. But you seem to have a history.
Lordship, since my senior is indisposed, if a short date may be granted.
That you did not tell me earlier. Difficult. Yes, madam.
Yes, Your Lordship, a short date may be given.
How short? How short the short date should be?
2 weeks, Lordship.
Your lordship, a week time you've given them.
Counsel, you are filing some additional affidavit.
Affidavit in reply, Lordship.
Reply. At least in the affidavit in reply, develop your case. Otherwise, you are in trouble. You are in trouble. Hurt, Mr.
Purwa Panglokam. Purwa Panglokam.
Learned counsel for the petitioner, who prays that he be granted a further 2 weeks' time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is not objected by the state council, who accordingly raised it to list this matter again on 17/2/2025. No further time. You are behind the bars or you have come out?
Come off.
Come out. No further time shall be granted to the petitioner for filing the affidavit in reply.
For admission, item number 2.
Anybody has entered appearance for respond number 7? Yes, madam. Why no affidavit?
Your lordship, my colleague is appearing in this matter, your lordship, and is in bereavement. So kindly grant 3 weeks to file this affidavit.
Any objection, madam?
No.
A prayer is made on behalf of the learned government advocate conducting the matter for an adjournment in the case, for an adjournment to facilitate filing of the affidavit in opposition by the state respondents. Prayer is not objected to by the learned counsel for the petitioner. Accordingly, raised to list this matter again on 24/2/2025. So no further adjournment shall be granted to the respondent authorities to file their affidavit in the matter. Interim order passed earlier. To continue till the next date of listing.
For admission, item number 3.
May it please the Lordship, I am appearing on behalf of my senior Gauhati, learned citizen. Lordship, we are yet to receive instruction in this matter. So if this matter can kindly come out after 2 weeks.
Why is the instruction not forthcoming? Because those notices were issued in the month of June. I had granted you time on 24/11. And with the stipulation that you must invariably file. Now again. So if you're not getting any instructions, forget it. We'll go with what is there on record. State has filed their affidavit.
Lordship, NHIDCL has, Lordship.
NHIDCL,
Yes,
2 and
Lordship.
3 has filed.
Now, in this case, Lordship, Union is a pro forma respondent, Lordship, because the project is implemented by NHIDCL.
NHIDCL, you have got nothing to do here.
Lordship, yes.
Who is for the NHIDCL?
Lordship, in fact, I have very simple prayer in this petition, Lordship. And granting the relief to this prayer will not prejudice the respondents in any way, Lordship. Because what I'm simply asking is that, Lordship, since I've been involuntarily displaced, now I have to relocate, we have to relocate, Lordships. Now we are running that, we're just poor farmers, Lordship. And nothing has been done. So what we are simply asking is for the respondents to conduct a assessment, Lordship. Verify.
When was the affidavit filed by the NHIDCL? 126. No, I got it.
Lordship, if you see the paragraph 5 of the affidavit of the NHIDCL, they are shifting the responsibility to the EPC contractor, Lordship. Now, Lordship, in this case, we're not disputing this because here, Lordship, we are unable to progress further.
Ma'am, give me 2 minutes.
Lordship, yes.
State has not come up with any affidavit.
Lordship.
Yes, Mr. Counsel, what is your stand?
Stand is also the district, the commission of the constitution. As to you get a complaint made by any of the beneficiaries, lodging and it has to be brought to the notice of the parties. Now, this issue has not been addressed by the deputy commissioner. It's been asked for. Now,
What we propose is subject to you agreeing,
Lord,
because the projection made by the petitioner in the present petition is that although the land of the petitioner is not acquired for the purpose, but due to the construction of the road, collateral damage has occasioned to the
No.
property.
Lordship.
Now, she has raised grievances before the deputy commissioner.
Lordship.
It seems that the deputy commissioner has done nothing. Now, without an assessment being carried out,
Lordship.
verification being carried out, the truth or veracity cannot be ascertained.
Exactly.
What we do is that we'll not enter into the merit of the writ petition.
Lordship.
We will ask the deputy commissioner to take on record her grievances and thereafter have a joint committee, joint verification involving the EPC contractor, NHIDCL, deputy commissioner and the petitioner
Lordship, yes.
within a period of 1 month and thereafter pass an appropriate
Lord.
direction. That much. only.
Obliged, Lordship.
Just get the names. I'll pass it. Disposed of.
Lord.
Obliged, Lordship.
For admission, item number 4.
Yes,
Lordship, in this matter, the counter affidavit was prepared and has sent to the deponent for
how long? When will you file it? When are you filing it?
after 2 weeks.
No, I want a date. Two weeks, 3 weeks were there when we were practicing. Now you have only dates. Mr. Counsel, take a date of your choice, but on that day, the affidavit should be on record.
Lordship, 12.
Mr.
Asilezo.
Azelezo, Learned Counsel, appearing on behalf of Ms. Yaranwati, Learned CGC, prays that the affidavit on behalf of the respondents represented by him shall be filed invariably on or before 12/2/2025. Also, on filing of such affidavit by the respondents, the petitioner is at liberty to bring on record his rejoinder thereto ipso advised. Within 2026, registry to list this matter again on 25/2/2026 for admissions. Oh, division 26, on 26/2/25. Sorry, I forgot that.
For admission, item number 5.
Yes, Mr.
This being the NTPS case, my affidavit in a position is under.
What is the status of the case,
under
criminal case?
proceedings.
Charge sheet has been filed?
Yes.
Charge sheet filed? No. In the criminal case, what has happened?
No. The disciplinary proceedings is going.
Forget it.
Yes.
What happened to the criminal proceedings?
It is under process,
No, but a charge sheet has been filed.
not yet. So I may be given 2 weeks time to file my application.
Yes, madam. What is your ground for challenge? Paul Anthony, GM Tang, then what?
Within 2 weeks time, I will file.
Oh, you file. But why? Why you want this disciplinary proceedings to be stalled? You are behind bars or you have come out?
It's already come.
Come out. Okay. Madam, it's not for asking. You will have to go a step further. You are not the arguing counsel? When will you file it?
On or before 17th of this month, within 2 weeks time.
Mr. L.T. Sangdam Leonard,
It is-
your additional Advocate General, Nagaland, prays that, submits that the affidavit on behalf of the respondents represented by him would be brought on record on or before
17th of
17/2/2025. For some, prayer accepted. The registry to list this matter again on,
19th.
we'll give him weeks time, on 27/2/2025. For some, the petitioner is at liberty to file his rejoinder. In the meanwhile, rejoinder upon filing of the affidavit by the state respondents.
For admission, item number 6.
My lord, this pertains to shifting of the main transmission line.
You are appearing for the,
State.
no. Who is for the, what do you call that?
Power grid, my lord. I appear for power grid, my lord.
What has happened? Now,
Respondent 667.
you have taken a decision to remove 50 to 152, string straight from 151 to 153. Have you carried out the works involved?
No, my lord, our stand is very straight here, my lord, that their querying activities is disturbing the tower.
You have taken a decision, Mr. Kera, in your
My lord.
affidavit. In your affidavit, you have come up that you have taken a call that 152 will be removed,
My lord,
151 to 153 directly. So the square there or not there is no issue. Now, have you done that?
my lord, this is, I believe the survey is under process. I will have to seek further instruction on
Come on,
this.
your affidavit is very clear.
Yes, my
But
lord, page
what happened?
35, page
What
35.
happened?
we have
Page,
taken.
after
Page-
page 94, come to page 94.
My lord. My lord, page 35, there is a categorical averment. Page 35, para 5.33, my lord.
No, there is something thereafter also. Okay, para 6.19.
My lord.
Now that you have taken a decision, why is it not taken to its logical conclusion?
My lord, we must have been going into the process of tendering the thing, and we will have to do a assessment survey also because the
You have
tender-
done it. You have done it.
My
You
lord.
have done it.
So, my
You
lord,
have done it. Your affidavit says that you have done it.
my lord, let the matter come up tomorrow. We will come up with the exact thing. What is
Why
happening?
not today? Why should we place it tomorrow?
My lord, give me. I think at the end of the board, then it can be taken up. My lord, I'll
Okay.
get these instructions. My lord.
You are concerned with 152, right? Tower number 152. You are carrying out querying activities below that. Admittedly not permissible. But now that the Power Grid Corporation has said that we will remove 152 tower and string directly from 151 to 153, you become inconsequential. Let us see what Mr. Kera has.
My lord, end of the board, my lord.
May I please, Your Lordship? I am not the lead counsel here. I'm appearing on behalf of my senior.
We want to help you out. You don't want to have that. Okay, fine.
My lord, we are also helping.
That's what I wanted to have this matter closed. That's
My lord, it may come up at the end of the board, my lord. In either way.
when will your senior be available?
Lordship, we are to file a reply.
Forget your reply. When?
Next week, Your Lordship.
Okay. On the prayer of the learned counsel for the petitioner, registry to list this matter again on (10/2/2025). Mr. N. Khera, learned counsel for the Power Grid Corporation, is present. Mr. Khera shall apprise this court on the next date of listing as to the steps taken by the Power Grid Corporation after a decision was arrived at by it to string the electric line straight from tower number 151 to tower number 153 and also to remove tower number 152. So just have it by 11th. I think I put it on 10, Mr. Khera.
My lord. My lord, our affidavit has been filed. It may be.
It's already on record. Why should I?
My lord, my lord.
Madam, they say that 152 they are removing. So whether you query or you don't query, it's of inconsequential now. I wanted to have this matter closed in your favor. Fine.
For admission, item number 8.
Obliged, my lord.
Please, Your Lordship, on behalf of my colleague, Mawson, Your Lordship, he's in bereavement, so kindly let the matter come up after 3 weeks. He's here to file his affidavit also.
Who?
Mawson, on behalf of the state government.
Mr. M. Lonkumer.
Yes, Your Lordship.
Yes, counsel.
Your Lordship, on the last occasion, the service reports were awaited for respondent numbers 6, 7, and 8.
Right. Service is complete. Seen the office note dated 14/1/2026, which reveals that service of notice upon respondent number 6, 7, and 8 is complete. Full stop. A prayer is made on behalf of Mr. L. M. Lonkumer, learned government advocate, representing the state respondents for an adjournment in the matter on the ground that he is presently in bereavement. So, prayer accepted. Registry to list this matter again on 23/2/2026. So, the state respondents shall invariably, before the next date of listing, bring on record their stand by way of filing an affidavit.
For admission, item number 9.
Yeah, please. May I please, sir? Lordship, in this matter, I'm yet to receive instruction. If some time can you can tell.
Returnable date. Okay. So and so learned government advocate prays that he be granted further 3 weeks time to file, to bring on record the stand of the respondents, state respondents, by way of filing an affidavit. Prayer is not objected to by the learned counsel for the petitioner. Accordingly, registry to list this matter again on 24/2/2026.
Blessed.
For orders, item number 10.
Next, my lord, by already that 8/12/2024, this whole court is right to be petitioner takes the performance to 5 by a service.
You lost it, then again
Again, I've taken.
permission, but
I'm yet to
the
receive the,
affidavit has not been filed.
not yet fine. I need to receive the.
You have not filed the rejoinder also. You have not
Yes.
filed the rejoinder also.
I'm yet to file my reply to be filed by respondents, private respondents as well as the state respondents. So I will give them at least 2 weeks time to file.
But there is an interim order continuing,
Interim order now.
so he'll have naturally have a grievance.
Lawful.
Hmm.
And we are returning the state respondent number 1, 2, and 3.
Hmm.
If the lordship could kindly hear me once
Hmm.
and say that the prison edition is not maintainable under 226 of the Constitution.
Hmm.
You see, your lordship, I have a pre-independence law, that is the administration of justice and policy in Nagaland, way back in 1937.
Hmm.
Under the rules, there is a provision where I think the customary form, that is the Dabashis form, where the Dabashis is.
Dabashis court.
Dabashis, under the civil condition.
Hmm.
So they can try cases, civil cases, which is endorsed by the deputy commissioner.
Hmm.
So accordingly, this dispute, it's a question of a small land dispute and a down.
700 by 700.
It's a district, a town in the Nagaland. So it was accordingly decided. As per the rules. As per the rule says, Rule 31 says, any decision taken by the village.
Council.
Question, I'm trying to address with the question of law here. Any decision taken by the Bashis or the village panchayat is, the bill can be made under Rule 31 before the deputy commissioner or his assistants. So living in that provision of law, the petitioner is here before this court under 226 of the Constitution, which is not substantial in the eye of the law.
Hmm.
May I please, my lord? My lord, I may be given some time to make a comprehensive reply to that.
So the very foundation of the case, is barred by law.
Now, what is the recourse available to the petitioner?
Your Lordship, it's a small dispute,
No.
like dispute.
No. If forget the dispute. We are on jurisdiction now. Now, if the order of the deputy commissioner
No.
is to be challenged, where would it be? It'll be high court.
Now, instead of going, the deputy commissioner and his assistants, they have come here.
But there is an order.
226 of the Constitution.
There is an order of this court, coordinate bench of this court, in a similar situation, wherein this court has said that the matter, there was some dispute with an earlier decision, and the matter was referred to the larger bench.
So,
What has happened to that procedure?
Look at it, Lord. Look at it.
Lordship, that issue is being handled by our Jurisdictional and I'm assisting me. It's still pending there. This is a decision of the village council. Where to go, whether by the civil court
Or by the
or
DC.
to the Deputy Commissioner as per the rules. That is,
No, after-
rules is the 1937 rules.
After the separation of the judiciary
Yes,
here,
yes.
whether any rules, fresh rules have been framed,
Rule is still there, even after separation of. 37 rule is still there.
still continuing.
It's still there.
They have not made any new civil rules for that.
No, no, sir, no. There is a small lacuna there.
Mm.
37 rule plus, because the bill is there. So decision of the village panchayat, we are to follow.
Now, how are the civil courts being functioning here? The civil jurisdiction courts in the districts, they are functioning under what provision? CPC, I understand, but is there any state civil rules? No, no rules.
Civil courts are now under the high court. Of the
I know that.
consideration.
That is for the procedure, you have the CPC. But any act made giving a status of a civil court to the village council courts?
It was like that. Some people used to go to the civil courts.
Some will go to the village court.
Some.
So it's a matter of,
Used to take up the cases. And it was.
you don't have a rule to that effect, act or
No. But here it is written petition, your lordship. The provision of the special law is very clear. 37 rule is, the rule is very clear. Decision of the domestic court.
okay, this court, while disputing that, has also held that the district and session judge will have no power under Rule 31 to hear an appeal from a Devashish court. The judgment that
The petitioner cannot invoke the extraordinary jurisdiction of this court under 226 of the Constitution, where there is a provision in the special law. This is what I mean with appraise your lordship. And the very disputed question of facts.
Yes, my lord.
Lordship, you can see my counter affidavit. Lordship, you will find.
My lord, may I please, my lord?
Counter affidavit filed by this thing.
May I take the lordship to page 46? He said in order. Period 394. Lordship.
no, this is what is under dispute.
Yes, lord. So, lordship, here, the petitioner has filed the appeal before the DC, and the DC endorsed the case to the Tobashi, and the Tobashi passed this order. That is my lord. It's not that we did not go before the DC. We went before the DC passed this. The DC endorsed the matter to the Tobashi. Lordship, I come to page 46, lordship. The translate copy. That's the issue, lord. My learned senior government brigadier is saying that I should have gone before DC. Yes, I've gone before DC. I was before DC. But the DC endorsed the matter to the Tobashi, and the Tobashi passed this order, the imperial order. And I'm saying that this order is bad in law.
That endorsement will not take the power of appeal away. You will have to go back
That's
under the provision of the act.
That's what we filed before the DC. But the DC endorsed the matter to the Tobashi.
Because he does not have jurisdiction. So he'll have to,
2 weeks time to file, basically, affidavit to the affidavit filed by the respondent's lordship. That issue has been raised in the affidavit, lordship, affidavit in opposition. I mean, give him some time, lordship. I'll satisfy lordship, I'll satisfy lordship. 2 weeks time, lordship.
23A complied with while endorsing the matter. Now, if there is a decision, it will be covered by 31.
Lordship.
Then what is the error? Why should we retain this petition here?
Also, I will give him some time, lordship, to file the basic reply to the. I'll satisfy lordship, lord. And lordship, unfortunately, my senior is out of station, and I don't even have a brief. I'm just referring to the.
After submitting so much, you don't require a brief. You know the matter otherwise also.
Lordship. But lordship, I will give you some time, lordship, to file a reply, lordship. A basic reply. specificity of the respondent and the.
I got your point now.
I think we are trying to file a certificate of service on respondent 5.
Just a moment, I never had an opportunity to examine this. Let me also appreciate it.
Yes.
Okay, so you say that you had gone before the Dobashi's court on with the matter being endorsed by the Deputy Commissioner. That's the procedure in 23A.
Okay.
So now, if that be so, the decision of the Dobashis will have to be in absence of any other rule. Appeal has to be on the basis of Rule 31. This is a rule. Okay. We give him a week's time, let him complete his instructions. And then next week we are disposing it off.
Next Thursday, Lord.
Otherwise, Lordship special law is very clear.
Okay, got it. I understood it now. Thanks for that input. The Learned Counsel for the petitioner prays that he be given time till 10/2/2026 to file his rejoinder to the affidavit filed by the state respondents. The Learned Counsel for the petitioner further submits that the affidavit envisaging service of affidavit of dusty service affecting service of notice by way of dusty mode upon the respond number 5 shall also be filed invariably by 10/2/2026. Full stop. In view of the above, the full stop, the prayer made by the petition, Learned Counsel for the petitioner is accepted. Full stop. Registry to list this matter again on 12/2/2025 for admissions. No further adjournment shall be granted to the petition, Learned Counsel for the petitioner for completion of the pleadings by the petitioner herein. Interim order to continue till the next date of listing.
For orders, item number 11.
By already 10, we are taking steps, but respondent 3 to 5 is 2 to 5 is yet to take steps also on 610.
2, 3, and 4.
2, 3, and
11.
Lordship,
13/10.
yes, Lord. Very good.
These are income tax authorities. Yes, Counsel. I find somewhere that your senior has made an undertaking that, or you have made an undertaking that you will be appearing for all the respondents. No. You are appearing for which respondent here? You don't have a standing counsel here, income tax.
Some things no. So, Lordship, there's one council, GST council, but notice has to go.
GST council is different.
Yes, notice has to go and only then the GST council, but not a special council.
I think then you will have to take fresh steps.
Lordship.
Steps in the matter was taken by the petitioner for service of notice upon the respondents number 2, 3, 4, and 5 by way of registered post, and thereafter notices were issued to the said respondents on 13/10/2025. First of, the office notes reveal that service of notice upon respondent number 5 is complete. However, the service of notice upon the other respondent, upon respondent number 2, 3, and 4 is not complete. First of, accordingly, the petitioner is directed to take fresh steps for service of notice upon the respondent number 2, 3, and 4 by way of speed post. No, fresh step for service of directed to take fresh steps for service of notice upon respondent number 2, 3 and 4 by way of speed post. Steps within 2 working days from today. Registry to list this matter again after 4 weeks, along with a report pertaining to the status of service of notice upon the respondents number 2, 3 and 4.
Also, there's an interim.
Interim order passed earlier to continue till the next date of listing.
For orders, item number 12.
Same.
Similar.
Same. Here the notice was issued on 13/10/25. Huh? 13/10. Earlier it was 14/10. This will be 13/10. Okay. Finished. Oh. A long time. I'm getting up at this time. Thank you.
Item number 3 again just la chamber of fail ne. Tai tarwa order pass kruba dispose kru. To file doing chamber de item number 3. PA kuina na. No le na dito down file.
Been registered and before the Chief Judicial Magistrate Calcutta and is still pending. Charge sheet has not been filed there.
This Kolkata case also pending.